give me a second here and I'll let you know. There you are. Okay, you are now live streaming, so mock trial is now in session. I will turn it over to Judge Boxberger to begin today's round 3.
All right, thank you, everybody. Again, welcome this morning. Let's go ahead and begin with the swearing in. If I could please have all team members turn on their video cameras at this time. And if you would all, team members, please raise your right hand. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
I do.
Yes, Your Honor.
All right. And then witnesses, if you would please raise your right hand. Do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
I do.
Yes, Your Honor.
I do.
All right, thank you. And scoring panelists, if you would please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
I do.
All right, thank you. Then we'll go ahead and begin. Court will be in session and we'll begin. If I'll ask just the attorneys to please enter their appearances. We'll start with Bermuda grass, with the I'm sorry, let's start with the plaintiff.
Sorry, is this for opening statement, Your Honor?
Well, I've been told I'm supposed to inquire if the attorneys would enter their appearance, which is typically your name and who you're representing.
Oh, okay, yes. My name is Reese McKinney and I am representing Dakota Weirs, the plaintiff.
And if each attorney for each team would do so.
My name is Tensing Sampera, and I will be representing the plaintiff, Dakota Weirs.
I am Chase Streeter, and I will be representing the plaintiff, Dakota Weirs, as well.
Thank you. And for the defense?
My name is Paige Weidman, and I will be representing Lush Fertilizer Incorporated.
My name is Sarah Gingras, and I will be representing the defendant, Lush Fertilizer Incorporated.
My name is Jade Garcia, and I will be representing Lush Fertilizer Incorporated.
Thank you. Let me inquire first of the plaintiff. Are there any preliminary housekeeping matters that we need to take care of before we begin?
Not at this time, Your Honor.
All right. And for the defense, any preliminary housekeeping matters before we begin?
Yes, Your Honor. I would like to make sure that both you and the jurors and opposing counsel have copies of the stipulated facts and exhibit notebooks.
The court does. I'll inquire of the jury members. They have all indicated they are in possession of those documents.
Fantastic. And I would also like to make sure that you, the jury, witnesses, and opposing counsel would be allowed to look at their unaltered exhibit notebooks when entering exhibits into evidence in order to speed up the flow of the trial and to avoid the technical difficulties that may come along with screen sharing exhibits.
And the court will so order. I think that will help with the flow of the trial. I'll ask that all parties have those exhibits in front of them rather than screen sharing.
Thank you, Your Honor.
You're welcome. Any other preliminary matters?
No, Your Honor.
All right, folks, I am going to ask that during the course of this trial, some preliminary procedural matters that everyone except the active participants turn off their camera and microphone. Attorneys and witnesses, if you are in the same room, just make sure your microphone is muted while the other individual is speaking. I know that's sometimes difficult, but that will help with any unnecessary feedback. All right. I believe that takes care of all the preliminary and procedural matters. Why don't we go ahead and begin with opening statements? We'll begin with the plaintiff's opening statement.
Thank you, Your Honor. Ladies and gentlemen of the jury, I am representing the plaintiff, Dakota Weirs. The plaintiff is suing Lush Fertilizer Co. for negligence on their behalf regarding their product, Drufo. Allow me to tell you about Dakota Weirs. A model student and a strong member of our community, Dakota is the president of their local school government. Dakota is part of the National Honor Society and is a student who gets good grades and puts in hard work in school. In what little free time Dakota has, they volunteer at their local homeless shelter and help those less fortunate. But above all else, Dakota Weirs was a talented and passionate piano player. Ever since they were a baby, they would play piano with their grandfather. And since their grandfather passed away when Dakota was 7, it was the only way they could keep his spirit alive. Dakota's passion and work ethic led them to win a full ride scholarship at Juilliard in New York. However, all of this was taken from them one summer. You see, every summer, Dakota would work for a lawn care company, and they would work with Lush Fertilizer products all day, every week, every month, every summer for years on end. All of this time spent around Lush Fertilizer led to Dakota developing non-Hodgkin lymphoma in their early 20s. Lush Fertilizer has destroyed the life of a wonderful human being, and they should be held responsible. We, the plaintiff, have the burden of proof. We will prove by a preponderance of the evidence that Lush knowingly produced a product that contained carcinogens and they were negligent. If you find that it is more likely than not that Drufo contains carcinogens and that Lush Fertilizer was negligent in their production of Drufo, then you must rule in Dakota's favor. Coming to the stand today, we will have Dakota Weirs, the victim of this horrible cancer. Dakota will testify to their use of Drufo and the effects of their cancer. Dakota will testify that they were not warned properly about the effects of Drufo. Next, we have Dr. Casey Rogers coming to the stand. Dr. Rogers will testify that Drufo does cause cancer. Dr. Rogers ran an experiment where the results concluded that Drufo was, in fact, linked to an increase in cancer. He will testify that Drufo causes cancer and will give scientific backing. Finally, coming up to the stand, we have Carson Durst, a scientist who worked for Lush Fertilizer for many years. Durst was part of the research and development team for Drufo, and they will testify that Lush Fertilizer knew the effects of Drufo and did nothing. They will testify that the CEO, Blake Doncourt, received an email about what was recommended to do in order to make Drufo safe and did nothing. Durst will testify that he was in a room where concerns of Drufo being potentially carcinogenic were raised, and these concerns were swept under the rug. These witnesses will prove by a preponderance of the evidence that Lush Fertilizer knowingly produced a product that contained carcinogens and then distributed it to the American people. Ladies and gentlemen, 2 of the defense witnesses are employees of Lush Fertilizer and are financially tied to the company. Their third witness, Skylar Weirs, has gambling debts, no college degree, and is the sister of the plaintiff. Blake Doncourt, the CEO of Lush Fertilizer, will claim that he never received an email where his name was listed with others in the sent to category. Ladies and gentlemen, Lush Fertilizer was negligent. They knowingly produced a product that contained carcinogens and then distributed it to the hardworking American people. They destroyed a life here today, a bright young student with a long and beautiful future ahead of them. And now they no longer have that future. We would like to ask for a sum of $3 million, as we believe this justly compensates for the pain and suffering of Dakota Weirs. We will prove by a preponderance of the evidence that Lush Fertilizer was negligent in their use of Drufo. Thank you, Your Honor. Thank you, ladies and gentlemen.
Great, thank you. Opening statements for the defense.
Yes, Your Honor. Thank you. Ladies and gentlemen, Lush is not liable. The current problem at hand was caused by a misguided opinion of who was to be held accountable for the situation at hand due to the plaintiff's neglect to understand the nuance of the situation. Recently, Lush Fertilizer Incorporated has been wrongfully accused of knowing and lying about Drufo, an alleged known carcinogen in their products. The plaintiff is Dakota Weir's, a 20-year-old currently suffering from non-Hodgkin lymphoma. Since they were 14, Dakota Weir's had been working for a landscaping company, Haven Landscaping, and due to their young age, was tasked mostly with spreading seed and many different kinds of fertilizers because they were unable to work the heavy machinery. During this time at Haven Landscaping, they were required to wear protective gear, such as a long sleeve shirt, long pants, a facial covering, and gloves, because these many different fertilizers were considered possibly toxic. However, out of ignorance, the plaintiff refused to follow these safety guidelines because they just loved the feeling of wind on their face and in their eyelashes and couldn't bear to stand the heat that came with following basic safety protocols. After being diagnosed with non-Hodgkin lymphoma, the plaintiff took to spending their time on the couch, and during one of these couch-ridden episodes saw a story on the news about how allegedly Lush had lied about the safety of their products. This shocked the plaintiff, seeing as they vaguely remembered sometimes using Lush Fertilizer's products while working at Haven Landscaping. And after some brief research and finding out that Lush was also banned in France and the rest of the EU, they decided they had all the evidence they needed to come to the conclusion that Lush caused their cancer. You will hear from Carson Durst, an old employee at Lush Fertilizer. He will tell you how he worked in research for Lush Fertilizer. He will tell you how he got his job because he was best friends with the CEO's son, Charles Doncourt. He will tell you that because of this, he was hired directly out of college, and after 3 months, went from simply having an internship to being a full-time product development engineer. And he will tell you that despite this, after constant abysmal performance reviews, he was fired. Then you will hear from Dr. Casey Rogers. She will tell you how Drufo got her attention as soon as it came on the market. She will tell you how she conducted a study. However, she won't tell you that she never had this published, presented it to court, or peer-reviewed. Then you will hear from the defense side. You'll hear from Blake Doncourt, the CEO of Lush Fertilizer. She will tell you how she pushes for legislative change to benefit the environment, and how she donates 10% of her company's annual profits to charities. She will tell you how there was no law, federal or state, stating that they had to put a warning on their products. She will tell you how when she studied Drufo, when her company studied Drufo, they found no valid scientific studies stating that it might be dangerous. Then you'll hear from Skylar Weirs, the plaintiff's own twin brother, testifying against Dakota in court. He will tell you the purpose of Drufo and how it benefits the environment and how it prevents other consumers from coming into contact with other pesticides, specifically arsenic. Then you will hear from Dr. Devin Williams, who will also tell you the importance of Drufo and will tell you the true statistics behind Drufo causing cancer. Ladies and gentlemen of the jury, it is your job to listen to these testimonies, to understand them in full, and to come to the conclusion that Lush is not liable. Thank you.
Thank you. Let's go ahead and begin. I'll ask the plaintiff's attorney to call their first witness.
Thank you, Your Honor. The plaintiff would like to call Mr. Dakota Weirs to the stand. Sorry, my camera. All right.
Oh, I'm sorry. Mr. Weirs, can you please raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right, thank you. Go ahead, Counselor.
Good morning, Mr. Weirs. Please state your name and spell the last for the record.
Dakota Weirs, W-E-I-R-S.
Before your illness, what did you do for a living?
Before the series of events that ended up with me here today, I worked at a landscaping company called Haven Landscaping.
And how long have you worked in landscaping?
I've worked in different capacities since I was like 14.
And outside of this work, how did you spend your free time?
With what little of free time I had, I would volunteer at local homeless shelters and help people who were less fortunate than me. And I was also part of my school's National Honor Society.
What brings you to this courtroom today, Mr. Weirs?
I've developed non-Hodgkin's lymphoma, and I believe the cause is lush fertilizer.
What is your work experience with lush fertilizer?
We worked very close to lush fertilizer at Haven Landscaping. It was one of the main products we used.
And how long did you work in such close proximity to lush fertilizer?
Almost every day for as long as I can remember working there.
Was safety equipment or clothing ever practiced in your use of lush fertilizer?
I mean, it was warm out, and if we had known that this would have caused cancer, we definitely would have. But among us veteran workers out in the hot sun, there was nothing being enforced.
Did anyone wear protective clothing?
Nobody.
If there were cautions about potential carcinogenic properties, what would have been done differently?
If we had known the actual extent of what this could do, we all would have been wearing all the protective gear, because it's not something I'd want to risk, but it's too late for that.
Do you have a sibling, Dakota?
I do, Skylar Weirs.
How has your illness impacted your sibling?
My dad has transferred funds that he was using to pay off Skylar's crippling gambling debts to pay for my treatment.
Has this financial shift made the relationship with Skylar difficult?
My relationship with Skylar's been better. I mean, I think she might have become salty that I've been quote unquote stealing his money.
Getting back to the damages of your illness.
Objection, speculation.
Response.
This just goes towards witness bias. It's less about the value of the testimony, rather his reaction and to this financial shift that occurred.
Is there any reply?
No, Your Honor.
All right, the court's going to overrule the objection, finding that it goes to motive, not bias of any other witnesses. Go ahead and begin.
Getting back to the damages of your illness, how has this illness impacted your life?
Not only have I lost the strength to help myself or volunteer, I also can't play piano anymore.
And how has this loss impacted your outlook and mentality?
At this point, I care less about my future that I would have had with a full ride at the Juilliard School of Music in New York. It's the fact that I can't even sit at the bench anymore.
Sorry to hear that, Mr. Weirs. Where did you find this passion for piano?
I played ever since I could walk. My grandfather taught me the basics, and piano's always been a medium for self-expression. Since
Objection,
my grandfather...
relevance.
Response.
Today, we are trying to discuss and quantify the emotional damages of this illness. It's something that will reach us to a financial settlement. Describing this loss, this passion, this is all entirely relevant to the discussion today.
Any reply?
No, Your Honor.
All right, overruled. I'll allow the testimony. Go ahead and continue, Mr. McKinney.
I'm going to restate the question, Mr. Weirs. I'm sorry, where did you find this passion for piano?
I've played ever since I could walk. My grandfather taught me the basics, and it's always been a medium for self-expression. Since he passed, it's been one of the only ways I've been able to connect with him.
Tell me more about this illness. How does the pain impact your day-to-day life?
The illness leaves me in constant and continuous pain. It's taken away my capacity to do the things I love, and it's ripped me of my future.
I'm so sorry to hear that, Mr. Weirs, and thank you. And thank you, Your Honor. No further questions.
All right, thank you. Any cross-examination?
Yes, Your Honor.
All right, go ahead.
Mr. Weirs, you worked for Haven Landscaping.
Yes, I did.
You worked with Lush Fertilizer at Haven Landscaping
I believe so.
and other fertilizers,
I believe so.
but you're only suing Lush,
Yeah, because they have Jufo in their products.
a successful company,
Yeah.
a
Objection,
wealthy
relevance.
company.
Response?
Your Honor, this question is relevant because as one is suing a company, we need to know why. I'm leading the question up.
If I may respond, Your Honor.
Go ahead.
We are talking about the success and the kind of value of the company in relation to Dakota Weir, someone who didn't work inside the company, just used one of their products. This is more about the work with Lush instead of the reasoning behind suing in terms of the success of the company.
All right, I'm going to overrule the objection, finding that this may go to motive or bias. You may answer the question, Mr. Weirs.
Thank you,
Could you
Your
restate
Honor.
the question, please?
A successful company.
I don't know. I wasn't really involved in their
A wealthy
company. I
company.
think so.
I would like to
Yeah,
talk
I
to you
don't
with about your time with Haven 6 years ago. You worked outside.
Yeah. It's a
You
landscaping
enjoyed
company.
working outside.
I mean, who don't? Who doesn't?
You enjoyed feeling the wind on your bare face while working outside,
It was hot.
Mr. Weirs. Your boss
It was hot.
always
Oh,
told
folks.
you to cover your face while working with fertilizer.
No.
You ignored these rules. You're supposed to always wear protective gear when working with these fertilizers.
It was never enforced. Nobody enforced it.
Gloves,
Wasn't
full
enforced.
coverage clothing, a
Still
covering
wasn't
of
enforced.
any sort to protect your face, Mr.
Was
Weirs.
not enforced.
You didn't wear those items. You wore only a
No, I
t-shirt
didn't.
on the job and shorts. You left most of your body entirely unprotected while working with these fertilizers.
At that point, I was wondering. I didn't even know what I was protecting it from.
I would like for the opposing counsel to direct their attention to their evidence packets, particularly Exhibit 1. Mr. Weirs, I ask for you to direct your attention to Exhibit 1 as well. What has been previously marked as Exhibit 1 for examination purposes. May I ask that the opposing counsel and Mr. Weirs direct their attention to the left portion of this exhibit titled Hazards in all caps. This exhibit clearly states as follows: caution. in all
Objection, facts
caps.
not in evidence.
All right, response?
May I please confer with co-counsel, Your Honor?
Yes, you may.
Mr. Weirs,
Oh,
do
wait,
you
I'm
recognize?
sorry, Ms. Gingras, do you have a response to the objection?
Sorry, may I please enter this exhibit into evidence, Your Honor?
Okay, is there any reply?
Well, there's just no foundation as to this so far, so I object to the admission of this into evidence.
Okay,
May I please have permission to build foundation, Your Honor?
I am gonna at this time sustain the objection, and Ms. Gingras, if you would go ahead and lay some further foundation prior to moving to admit the exhibit.
Okay. Mr. Weirs, I ask for you to direct your attention to what has been previously marked for identification purposes as Exhibit 1. Do you recognize this portion of evidence?
I do not.
May I permission to confer with co-counsel?
Go ahead.
Mr. Weirs, you do not recognize this packaging for Lush fertilizer?
I do not. At least not from when I worked for Lush Fertilizer, I should say. For Haven Landscaping, my bad.
Mr. Weirs, do you remember writing a witness statement?
I do remember.
And in this witness statement, you were being as accurate as possible?
Yes, I was.
And it includes all relevant facts?
Yes, it does.
And you knew you could update this witness statement at any time before trial?
Mhm.
Your Honor, let the record reflect that I am showing opposing counsel what has been previously marked as Mr. Weirs' witness statement. Your Honor, permission to approach the witness.
Permission granted, and for the purpose of this virtual proceeding today, Mr. Weirs, if you could pull up your witness statement.
Okay.
Go ahead, Ms. Congress. You can continue with your cross-examination.
Mr. Weirs, please open your witness statement to page 16, particularly lines 135 and 136. Is this your signature?
That is my signature.
Thank you. On line 87 and 88, you said that your father found an old package of the Lush product we used and you had him send you a picture. Exhibit 1 fairly and accurately shows a Lush fertilizer label just as you remember it. Mr. Weirs.
Yes. I don't think you heard correctly what I said earlier. I said I did not recognize this packaging from when I worked at Haven Landscaping. I do recognize it. I just don't recognize it from when I worked.
Mr. Weirs, I asked you if you recognize this exhibit. You only added on the part where you didn't recognize it from when you had worked with Haven until after I had asked that question.
Well, it was still clarified.
Mr. Weirs, I'm going to ask you this again. Do you recognize Exhibit 1?
I do recognize it.
Thank you, Mr. Weirs. Let me continue with this. I would ask the opposing counsel to direct their attention to what has been previously marked as Exhibit 1 for examination purposes. Your Honor, may I please enter this into evidence?
Any objection to the request to admit Exhibit 1?
Yes, Your Honor, on the grounds of hearsay, it is an out-of-court statement.
Okay. Any reply?
I do have a question. How is this hearsay, Your Honor?
I'm going to go ahead and overrule the objection at this time and allow admission of Exhibit 1.
Again, I ask that the opposing counsel and Mr. Weirs direct their attention to the left portion of this exhibit titled Hazards in all caps. This exhibit clearly states as follows: caution in all caps. Causes eye irritation. Avoid contact with eyes and clothing. I ask that the opposing counsel now direct their attention further down the page.
Attorney testifying. We're reading the contents of a document. These should be asked in the form of a question.
Ms. Kingross, any response?
Mr. Weirs, may I please have you read this yourself?
Hold on just a minute. I just need to respond. I need to rule on the objection. I'm going to sustain the objection.
No response, Your Honor.
All right. Thank you, Ms. Kingross. Go ahead and ask your next question.
Mr. Weirs, may I please have you read the section underneath caution in all caps?
Causes eye irritation. Avoid contact with eyes of clothing. What?
I ask that the opposing counsel now direct their attention further down the page where one may find the user safety recommendations, again, in all caps. This exhibit has clearly stated and labeled its user safety recommendations in all caps.
Objection.
Mr. Weirs.
Attorney testifying. Again, this is all needs to be asked in the form of a question.
Any response to the objection, Ms.
No response, Your Honor.
I'm going to sustain the objection. Ms. Greengrass, if you could just direct questions towards the witness moving forward. Thank you.
Mr. Weirs, could you please read the user safety recommendations on this page?
As with any spray fertilizer, use protective clothing that covers exposed skin. Use of a respirator or N95 face mask is recommending. Follow manufacturer's instructions of cleaning and maintaining personal protective equipment.
Now I ask the opposing counsel to direct their attention to the last sentence of Exhibit 1. Mr. Weirs, would you mind reading this aloud?
Use of a, is it users should wash hands or use of a respirator?
Yes, sir.
That did not answer my question.
Yes. Please read that sentence.
I'm asking which sentence, not yes or no. Is it use of a respirator or N95 face mask, or users should wash your hands before and after?
Mr. Weirs, please read the last sentence on the bottom of the left portion of the exhibit.
All right. Users should wash hands before and after use of this product.
Mr. Weirs, it was required by your employers that you should always protect yourself while working with these fertilizers.
It was not required. It wasn't enforced.
Mr. Weirs, just to clarify again, you did submit a witness statement?
I did submit a witness statement.
And your signature is the signature on the bottom of that page, and you were aware that you could update it before this trial.
Yes, I am aware.
I would ask opposing counsel and ladies and gentlemen of the jury to direct their attention to lines 62 and 63. My boss always told me to cover my face when I was working with chemicals, but sometimes it was just too hot. Mr. Weirs, your boss always told you to protect yourself.
Objection, hearsay.
Response.
Your Honor, the witness clearly stated in their witness statement that their boss always told them to protect themselves.
If I may respond.
Go ahead.
By definition, that's hearsay. It's using an out-of-court statement said by someone else. Hearsay.
All right, I'm going to sustain the objection, finding that it is a hearsay statement. Go ahead, Ms. Gingras.
No objections, Your Honor. Thank you, Mr. Weirs. No further questions.
All right, any redirect?
Yes, Your Honor, briefly. To Mr. Weirs, did anyone ever use any protective clothing on the job site?
Not a single person.
Was it normal or expected to?
It was not expected to at all. None of the veteran workers like me ever used any sort of protection because we didn't know the consequences.
If this warning label had proper cautions about potential carcinogenic properties, would you have worn protective clothing?
I would have. 100%.
Thank you. Thank you. Yeah, sorry. Thank you, Your Honor. And thank you, Mr. Weirs. No further questions.
Thank you. Any recross?
No, Your Honor.
All right, thank you. If the plaintiff would please call their next witness.
Your Honor, the plaintiff calls Dr. Casey Rogers to the stand.
All right. Dr. Rogers, can you please raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Thank you. Go ahead, counselor.
Please state your name and spell your last for the record, please.
Dr. Casey Rogers, Rogers.
What is your current primary profession, Dr. Rogers?
I am currently employed as a professor in the horticulture and entomology department at the University of California, Berkeley.
What courses do you currently teach at University of California at Berkeley?
I currently teach Intro to Horticultural Entomology, Horticultural Entomology Food Crops, and Herbicide Selectivity in Action.
What college degrees do you currently hold?
I hold a Bachelor of Science in Agriculture and Chemistry, as well as a PhD in Agriculture and Entomology.
Where exactly did you earn these degrees?
My bachelor's was earned at Colorado State University, and my PhD was earned at the University of California, Berkeley.
What projects are you currently working on?
I'm currently researching in the Environmental Chemistry and Toxicology Lab, which emphasizes pesticide mode of action and metabolism. This information helps optimize pesticide use and improve selectivity and environmental characteristics. It also minimizes the hazards of pesticides on humans.
What did you do before your work at UC Berkeley?
I was a research analyst for a large and confidential multinational chemical company.
What has been the main focus of your research?
The main focus of my research has been pesticide chemistry and toxicology. During my career, I have researched the long-term health effects of prolonged exposure to potentially harmful substances, and this includes the chemical DRUFO.
What research do you have about the impacts of chemicals?
I have a number of scholarly articles written about the negative effects of prolonged exposure to various chemicals, especially DRUFO.
What has your research been used for in the past?
My research has not only been used in litigation and before administrative advisory boards, but I have also made recommendations to companies and regulatory agencies.
Dr. Rogers, will you please refer to what has been marked as Exhibit 6, which has been provided to opposing counsel and jurors?
Yes, I can refer to that exhibit.
What is this document?
This is my current and up-to-date curriculum vitae.
Does this document contain evidence that is not included in your prior testimony?
Yes, it does.
Now, will you please direct your attention to what has been marked as Exhibit 7, which has also been provided to opposing counsel and jurors?
Yes.
Can you confirm what this document is?
This is my up-to-date list of my research publications.
Does this document contain evidence that is not included in your previous testimony?
Yes.
Your Honor, the plaintiff would like to request the entry of Exhibit 6 and 7 into evidence.
Any objection?
No objection, Your Honor.
Exhibit 6 and 7 will be admitted.
Your Honor, the plaintiff also asks the court to qualify Dr. Casey Rogers as an expert under Rule 702 in the field of pesticides, specifically DRUFO, and their impact on the human body.
Any objection?
No objections, Your Honor.
The witness will be so qualified.
Thank you, Your Honor. Dr. Rogers, what led you to do additional research on DRUFO?
I have focused on agricultural chemicals for most of my professional career, but DRUFO caught my eye because I feel it was rushed into production without sufficient studies about its safety. So I, therefore, decided to conduct my own research on the chemical DRUFO.
Did your research ever reach a conclusion?
Yes, it did. I have reason to believe that DRUFO could be carcinogenic.
What made you think that DRUFO could be carcinogenic?
There is a study published that showed that DRUFO was carcinogenic in rats. So I had reason to believe that it could be the same for humans.
What exactly did you do to test the effects of DRUFO?
I created a study that followed 3 different groups of people with varying exposures to DRUFO. I started with a control group that had no exposure to DRUFO, a second group with moderate and occasional exposure to DRUFO, and the third group had a high and almost daily exposure to the chemical DRUFO.
What were the results of this study?
I was able to find out that over a few years' time, there is an increase in health conditions, particularly cancer, in people who were exposed to DRUFO in comparison to the previously mentioned control group. The study discovered that people with prolonged exposure to DRUFO were much more likely to be diagnosed with cancer.
Were there any recommendations that you found that would help prevent the health issues associated with using DRUFO?
I was able to find ways to mitigate the risk involved with using the chemical DRUFO. The biggest thing is to wear long sleeves and long pants to avoid your skin coming in contact with the chemical. Also, people using DRUFO in an aerosolized version should wear a medical grade protective face mask like an N95.
Are there any caveats with this recommendation?
Unfortunately, the majority of people who use DRUFO do not have protective equipment provided to them or recommended to them. Therefore, the results of this study are inconclusive as there was insufficient time to study the long-term effects of using protective gear to prevent exposure.
Thank you. No further questions, Your Honor.
Thank you. Any cross-examination?
Yes, Your Honor. Dr. Rogers, you're a professor?
Yes, I am.
And you've been studying the effects chemicals have on the body?
Yes.
Specifically the harmful effects?
Yes, that has been a focus of my research.
And you've published many articles
Yes, I have.
about this research?
Yes, my research publications are listed in Exhibit 7.
Thank you. Which has been used in litigation before,
Yes, my research has been used in litigations.
but this is your first time testifying as an expert witness,
Yes, it is.
and you hope it won't be your last?
Objection, Your Honor. Relevance.
Response?
This particularly shows a financial bias in Dr. Casey Rogers' statement.
Any reply?
Money.
Most of the people here are being paid to be here and paid to testify or represent either side. So I think that it is not necessarily specifically specific to this witness.
All right, the court's going to allow the question finding that it goes to motive and bias.
Could you please restate the question?
You hope it's not your last time testifying as an expert witness.
I'm sorry, you cut out. Could you repeat that one more time?
My apologies, Dr. Rogers. You hope this won't be your last time testifying as an expert witness?
I would like to show that Drufo has had harmful effects on many different people.
So Drufo got your attention as soon as it came on the market?
Yes, I felt it was rushed into production.
So you put together a study,
Yes, I created a study.
and the study lasted years.
Yes, there is no way to see effects immediately.
But you never provided us with this study?
I, as an expert, have conducted this study and can testify about what is included in the study.
But you never provided it.
My entire study is not outlined in this case, no.
Okay, no further questions, Your Honor.
Thank you. Any redirect?
Yes, Your Honor. Dr. Rogers, why exactly are you testifying here today?
I am here to testify about the harmful effects of Drufo because I know Drufo is harmful and carcinogenic.
Is there any monetary bias to be here right now?
No, of course not.
No further questions, Your Honor.
Any recross?
No, Your Honor.
All right, if the plaintiff would please call their next witness.
Thank you, Your Honor. The plaintiff would like to call Mr. Carson Durst to the stand.
All right, Mr. Durst, can you please raise your right hand? Do you swear or affirm under penalty of perjury the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
All right, go ahead.
Thank you. Could you please state your name and spell your last name for the record?
My name is Carson Durst, D-U-R-S-T.
Thank you. And where did you attend college, Mr. Durst?
I attended college with my friend Charles Doncourt at Arizona State University.
Thank you. What did you major in at ASU?
I majored in and got my bachelor's in chemical engineering.
Okay. And how long have you been working with pesticides or other lawn care products?
I've been working with pesticides since my employment at Lush Fertilizer as an intern in 2003.
Okay, and do you know the Doncourts?
Yes, I do.
What was your relationship with the Doncourts?
They were like the family I never had. Charles, the son of Blake Doncourt, he was my best friend, and we played soccer together as kids. I basically became part of the family. I go to their lake house in the summer and have Sunday dinners with them. We all became inseparable, and they were all family to me.
Thank you. And who is the CEO of Lush Fertilizer?
I'm sorry, could you repeat that?
Who is the CEO of Lush Fertilizer?
Blake Doncourt is the CEO of Lush Fertilizer.
And so has your relationship with the Doncourt family affected your job at Lush Fertilizer?
In terms of my professional career, no, my relationship did not affect my job. even though Blake was the one who hired me, I was more than qualified for the position. And my relationship with them also led to the stipulation I was getting handouts from Blake and not pulling my own weight, but that was simply wrong. And everybody else was just jealous that I was performing at a higher level than the more experienced employee.
Objection calls for speculation.
Response?
This is just simply not speculation. I'm asking how the relationship with the Doncourts has affected his job, and he is testifying as to how it affected his job.
Any
May I
reply?
respond? Yes, Your Honor. The witness said that his coworkers were jealous of him, and that is not something that he would have any ability to know.
Right, the court's going to find that the question didn't call for speculation, but the witness's statement was speculative in nature. Ms. Weidman, are you asking the court to strike that portion of the witness's statement?
Yes, Your Honor. Thank you.
The court will so strike. Go ahead, Mr. Sempera.
All right. So your relationship with the Doncourts. How has your relationship with the Doncourts affected you in your professional setting?
It did not affect me. I did my job and that was it.
Thank you. And so, how long have you worked for Lush Fertilizer?
I worked there for 3 years, from 2003 to 2006.
Thank you. And what did you do for Lush Fertilizer?
I started as an intern on the research and development team, and then after a few months, I got promoted to a product development engineer.
All right. And what did you oversee as a product development engineer?
I oversaw development of a particular chemical compound within Drufo.
Okay. And while you were part of the Drufo team, did you witness anything regarding carcinogens in Drufo?
Well, my job was testing the safety of that particular chemical compound in Drufo and whether or not it was carcinogenic. And we were also testing it as we developed it, and there was reason to believe that it was carcinogenic.
Thank you, Mr. Durst. Give me a sec. I'm having some technical issues. Okay. And were there concerns raised about Drufo being carcinogenic?
Yeah, there were a few employees.
Okay. And what were the reactions to these concerns?
In the meeting where it was brought up, Alex Monroe, an upper echelon employee, concluded it with the words, "Let's keep it in the walls."
Objection, hearsay.
Response?
Your Honor, this is a party admission. Alex Monroe was a member of Lush Fertilizer, and that is the opposing party, and he was an employee, and therefore this is a party admission, which under Rule 801, subsection D, subsection 2, this is a party admission, therefore an exception to hearsay.
Any reply?
I stand by my previous statement, Your Honor.
Okay, the court's going to overrule the objection. Mr. Durst, you can answer the question.
Would you like me to re-ask the question?
Yeah.
What was the reaction after the concerns of Drufo being carcinogenic were raised?
So in the meeting, Alex Monroe ended it with the words, "Let's keep it in the walls until we figure out what we are doing," which surprised me because there's also mention that Drufo could be specifically linked to non-Hodgkin's lymphoma. And it was obvious to me throughout the studies that there was pressure from upper management for us to influence the numbers to make it seem like Drufo was safe. And I don't think it's a coincidence that that's why we're here today.
Thank you. Mr. Durst, could you please pull up Exhibit 4?
Yes, I can. I have it.
All right. Are you currently looking at Exhibit 4?
Yes, I am.
What is Exhibit 4?
It's an email sent out to a bunch of Lush Fertilizer employees by Gary Langley.
Okay. Could you give some context to this email?
Yeah, it was a confidential email sent to me, Blake Doncourt, and many other employees, specifically on the research and development team. And it talked about the results of the most recent in-house study and the reinitiation of that study due to the rising concerns about Drufo being carcinogenic.
Thank you. Your Honor, we would like to enter Exhibit 4 into evidence.
Any objection?
Yes, Your Honor, I object to hearsay again.
Response?
Your Honor, this is not hearsay. This is again a party admission as it was sent by an employee of Lush Fertilizer for the reasons previously stated. Under Rule 801, subsection D, subsection 2, this is a party admission, therefore an exception to hearsay.
Okay. And the exhibit will be admitted at this time.
Thank you. I would just like you to clarify, could you list a couple of names as to who the email was sent to? Could you just like read the sent portion?
So it was sent by Gary Langley to me, Blake Doncourt, Aaron Stevens, Adam Gwynn, Alex Monroe, Brown Yadaby, John Schmidt, Judy Bishop, and a bunch of other people. Yeah.
Okay, I would just like to clarify, Blake Doncourt's name is on that list. Is that correct?
Yes, it is right there.
And so what was recommended to make Drufo safe in this email?
Just the possibility of it being carcinogenic should have been enough to convince upper management to bake it, which was recommended by a fellow employee, because it would have gotten rid of all its carcinogenic properties and made it safe to use.
And I'm just going to clarify that. Baking Drufo would have removed any risk of it being carcinogenic. Is that, yeah?
Yes, that is true.
Okay.
Objection, leading question.
Yeah. Your Honor, could I please restate that question?
Court's going to sustain the objection. Go ahead, Mr. Sinclair.
Baking Drufo would baking Drufo have removed any sort of carcinogens?
Yes, it would have made it safe to use.
All right. Should Lush Fertilizer have baked Drufo?
Yes, I think so. And as a
Your
company,
Honor, objection, this calls for expert testimony, and this witness is not an expert.
Response?
Your Honor, under Rule 701, subsection A and subsection B, this answer is well within this witness's perception, as they were surrounded for 3 years of their life, as well as have a bachelor's in chemical engineering. They were surrounded by fertilizers their whole life, as well as it helps clear up the witness's testimony and answer the question at hand of whether or not Drufo causes cancer and whether or not Lush was negligent in their production of Drufo.
Any reply?
Yes, Your Honor, the question was phrased in a way that the witness was asked whether or not the fact was true. And I do not have an objection with the witness's answer, in which he said that I think, proceeded to state the fact, but the question itself calls for expert testimony.
Your Honor, if I may reply.
The court, I'm not
sorry.
going to allow for another reply because of our time constraints. I am going to sustain the objection, finding that it called for expert testimony in an ultimate issue before the court today.
Okay. I'm just going to continue. Do you currently work for Lush Fertilizer?
no, I don't.
When were you fired from Lush Fertilizer?
I was fired in 2006.
Thank you. And where are you currently employed?
I work for Terrace Greenery. I've been working there since 2006.
And was there a non-compete agreement signed between you, Lush Fertilizer, and Blake Doncourt?
Yeah, I signed it when I started my employment there, but I didn't remember that I signed it when I switched jobs. And then a legal battle ensued, and the settlement that was agreed upon was that I would wait 6 months before starting at Terrace Greenery. And so I did, and then that was it, and then it was resolved.
All right, thank you, Mr. Durst. I have one final question. Why are you speaking out against Drufo now?
I realized that I had to speak out for what is right in order to hopefully stop more cases like Dakota's from happening. I mean, despite my personal connection to the Doncourts, I mean, I do feel a connection with them, but I had to look past that and just realized that what they were doing was wrong and developing a carcinogenic property, and they tried to cover it up by influencing their numbers.
Thank you, Mr. Durst. That will be all. Your Honor, the plaintiff has no further questions.
All right, thank you. For the defense, any cross-examination?
Yes, Your Honor. Thank you. Mr. Durst, you were hired by Lush Fertilizer in 2003
Yes, I was.
as an intern
Yep.
in the research and development team.
Yes.
Your boss was Blake Doncourt,
Yes, he was.
a close family friend.
Objection, Your Honor. That question has no relevance to the question at hand. The question at hand is whether or not Lush Fertilizer was negligent in their production of Drufo. My witness's relationship with the Doncourts is not a question here.
Any response?
Yes, Your Honor. This line of questioning could show potential bias, which is vital to the understanding of this case and witness.
Reply? Any reply?
What
Mr.
would- I would just like, no, Your Honor.
All right, the court's going to overrule the objection. You may continue, Ms. Weidman.
Blake Doncourt was a close family friend,
Yes, he was the father of my best friend as a child.
and he pulled some strings.
Objection, Your Honor, speculation. There's no
Response?
way of proving that Blake Doncourt pulled any strings.
Response?
Your Honor, I'm not asking whether or not Blake Doncourt did. I am asking whether or not the witness believes that.
Okay, in that case, Your Honor, may I change my objection?
Go ahead.
Argumentative question. The question is asking my witness to accept the opposing counsel's conclusion rather than a fact.
Response?
Yes, Your Honor, that is the point of cross-examination.
All right, I'm going to sustain the objection at this time.
All right. Mr. Durst, you quickly rose in the ranks of Lush Fertilizer.
Yes, I did my job and the natural effect came to me.
And you were tasked with researching one of the compounds composing Drufo.
Yes.
One of them.
Yes, I was on a team of many other people who researched the whole thing.
Thank you. You were sent an email about Lush Fertilizer's in-house study,
Yes, I was.
and it was unclear to you.
Objection, Your Honor. Speculation.
Response?
Yes, the witness in answering this question will be testifying to his understanding of a question, which requires no speculation whatsoever.
Oh, okay. In that case, I withdraw my objection, Your Honor.
Okay. Go ahead and repeat the question, Ms. Weidman, if you can, please.
Yes, thank you, Your Honor. Lush Fertilizer's in-house study email was unclear to you, Mr. Durst.
I mean, what they said in it was unclear, but it was clear to me with my experience that Drufo was carcinogenic. I think they were just trying to cover it up.
But what they said was unclear.
In the email, yes.
You received the study report a few months later,
Yes, I did.
and its conclusion was that Lush's statistics and distribution is below what is required by law.
That's what they said. However, I don't think that's true.
Non-Hodgkin lymphoma was not addressed anywhere in this report.
No, it wasn't.
Your performance reviews began to decrease in quality.
Yes, I think everybody else was just jealous because I was performing at a higher level, though.
Of course. And you went to talk to Blake Doncourt about this.
Yes, I did.
And he told you that you were lucky to even have a job.
Objection, Your Honor. This question has no relevance to witness bias or the question at hand regarding negligence of Drufo and Lush Fertilizer.
Response?
Yes, Your Honor, this does in fact go towards the witness's bias towards Blake Doncourt.
Any reply?
No, Your Honor.
Overruled.
Blake Doncourt told you that you were lucky to even have a job.
Yeah, he did.
Objection. Hearsay.
Response?
Your Honor, this question does not go towards the truth of the matter asserted.
All right, I'm going to overrule the objection at this time.
Okay.
Would you mind answering that again, Mr. Durst?
Do you state the question again?
Of course. Blake Doncourt told you that you were lucky to even have a job.
He said that I was hired by more professional employees. However, that didn't affect what I did. I just did my job, and yeah.
I'm sorry, Mr. Durst, could you answer my question directly?
Yes, he did say that.
You believe that he should have given you a different reaction.
Well, I mean, yes.
Yes. Because he was your longtime family friend.
No, because I did my job.
Of course. You became angry with Lush Fertilizer.
Objection,
No.
Your Honor, speculation. This is the question is asking about something that's only speculation. The question itself is speculative.
Boss?
No, it is not. I am asking if the witness became angry with Lush Fertilizer, which the only knowledge needed to answer that is his own personal feelings.
Okay. I'm going to overrule the objection.
Mr. Durst, you became angry with Lush Fertilizer.
No, I wasn't.
You didn't.
No. I realized that what Blake had said was probably just because of his divorce with his wife, and I wasn't angry.
Oh, so you believe that all of this had to do with Blake Doncourt's personal life?
No, I'm just saying that his attitude in when I talked to him was probably just a reflection of what he was feeling with his divorce.
All right, of course. So you looked into Terrace Greenery.
Yes, I realized it wouldn't work well with me and Lush.
And Terrace Greenery is a direct competitor to Lush.
Yeah, they work in fertilizers. It made sense to keep working in fertilizers.
And you applied for an open position
I did.
while still working for Lush Fertilizer.
Objection, relevance. I don't understand how my witness working for starting another job is relevant to the case at hand. And I do not believe it goes to witness bias.
Response?
Yes, Your Honor. I have established that Terrace Greenery is a direct competitor to Lush, so this question would reveal bias against the company.
Any reply?
Yes, there was a non-compete agreement signed between these two as previously established in my line of questioning. So witness bias has no relevance here.
I'm going to overrule the objection at this time. If Mr. Durst, if you could answer the question.
Can you say it again, please?
Yes. You applied for Terrace Greenery while still working for Lush Fertilizer.
Yes, I did.
And you were fired from Lush Fertilizer in December of 2006.
Yes, and then went to work for Terrace Greenery.
But you were already hired by Terrace Greenery when you were fired,
Yes.
violating your confidentiality agreement with Lush Fertilizer.
Objection. This contains facts, not evidence. The opposing counsel has not brought the non-compete agreement into evidence and is using the non-compete agreement as evidence.
Response?
Yes, Your Honor. Because opposing counsel has already referenced this exhibit without entering it as evidence, I believe that it is perfectly reasonable for me to reference this exhibit.
If I may respond.
Go ahead.
I referenced it and I just purely asked if there was one signed. However, opposing counsel said that this violated it, and they have not established any foundation as to whether or not as to what the non-compete agreement actually said. So this is all speculation.
All right. The court's going to overrule the objection, finding that if the witness has knowledge regarding the contents of the non-compete agreement, he may testify to the contents therein.
Thank you, Your Honor. I'll ask the question again, Mr. Durst. Being hired by Terrace Greenery while you were still hired by Lush Fertilizer violated your confidentiality agreement.
Like I said, it did, but we went to court and it was resolved. I waited 6 months and everything was fine.
All right, but you still violated it.
Yes, because I didn't remember that I signed it.
All right. Mr. Durst, you believe that Terrace Greenery, your current employer, may overtake Lush Fertilizer as having the best-selling fertilizer on the market.
Yes.
I have no further questions, Your Honor. Thank you.
Any redirect?
Yes, Your Honor. Just a real quick redirect. You graduated with a bachelor's in chemical engineering. is that correct?
Objection, not in the scope of redirect.
Sorry, did you ask for a response, Your Honor?
Yes, to the objection of outside the scope of cross-examination.
No response.
All right, I'm going to sustain the objection, finding it is outside the scope of cross-examination.
Were you qualified for your position?
Yes, I was.
Thank you. No further questions.
Any redirect or any recross?
No, Your Honor. Thank you.
All right, thank you. Do the plaintiff have any additional witnesses?
No, Your Honor. The plaintiff rests.
All right, let's turn to the defense case in chief. Would the defense please call their first witness?
The defense calls Blake Doncourt to the stand.
All right, thank you. Ms. Doncourt, can you please raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Thank you. Go ahead, Ms. Garcia.
Please state your name and spell your last for the record.
Blake Doncourt, Doncourt.
And Ms. Doncourt, why are you here today?
I'm here to testify on the behalf of my company and refute the plaintiff's accusation.
All right, Ms. Doncourt, what do you do for a living?
I'm the CEO of Lush Fertilizer.
And would you consider your company, Lush Fertilizer, successful?
Yes, I would. My company is able to donate.
Objection, relevance.
Ms. Garcia, any response?
Permission to confer with co-counsel, Your Honor.
Go ahead.
This is relevant. I asked a question about Lush Fertilizer, and the current case at hand is almost entirely revolving around Lush Fertilizer, so it lays foundation.
If I may respond, Your Honor.
Go ahead.
The line of questioning talks about the success of the company, when in reality, what we're discussing in court today is the potential carcinogenic properties of Drufo and their product Lush Fertilizer. The success of the company has nothing to do with this subject, so it's irrelevant to the case at hand.
I'm going to overrule the objection. Ms. Doncourt, you can answer the question.
Would you mind reiterating the question?
Yes. Is your company successful, Ms. Doncourt?
Yes, my company is successful. We're able to donate 10% of our annual profit to charities.
And have you been personally recognized for these efforts?
Yes, personally, I have been nominated for the United Nations Champions of the Earth Award.
What
Objection.
about your
Relevance. The awarding of environmental efforts is once again not relevant. While the success of the company may be relevant to the case at hand, its environmental efforts are not. Additionally, that it can go towards character evidence, which is acting as Ms. Doncourt acted in accordance with the character trait of being environmentalist and being awarded for that, which is not admissible, as character evidence cannot be used to account for a later action.
Ms. Garcia, any response?
Your Honor, may I confer with co-counsel?
Go ahead.
I would again like to say everything having to do with Lush is extremely important.
All right, I'm going to sustain the objection, finding that it is not relevant to the issues at hand.
Okay, Your Honor, I'll move on. Could you further explain, Ms. Doncourt, the claims being made?
Yes, Lush Fertilizer is being wrongfully accused of negligence on behalf of our fertilizer.
What do you mean by being accused of negligence?
Well, I mean, Lush Fertilizer is being accused of ignoring an alleged carcinogen, Drufo, as you know, a bonding agent in our fertilizer.
Did you ignore this alleged carcinogen?
No, of course not. My company would never ignore something that could potentially cause harm to people.
Did Lush Fertilizer do any research on Drufo?
Yes, Lush has done many, many years of extensive and thorough research on Drufo to make sure that there was no substantial risk to the use of our product.
Besides your research done by your company, have any other organizations found Drufo to be harmful?
To my knowledge, no other organizations, not my scientists nor the EPA, have found anything.
If there was data, what would you have done about it?
Well, if there was anything suggesting that Drufo might be harmful, we would have either put warnings on our packaging immediately or just never released the product onto the market.
Moving on, are you familiar with Carson Durst on the plaintiff side?
Yes, I am.
What is your relationship with Mr. Durst?
Well, I hired Carson Durst back in 2003 to work for me at Lush Fertilizer.
I'd like to draw your attention and opposing counsel's attention to your exhibit packet, specifically Exhibit 4. Ms. Doncourt, what is Exhibit 4?
This appears to be an email.
Do you recognize Exhibit 4?
No, I do not.
Do you remember getting it?
I'm sorry,
No,
Ms.
I do not
Garcia,
recall.
can you re-ask the question? You cut out there.
Ms. Court, do you remember ever getting this email?
No, I do not remember getting it.
Do you get many emails a day?
Well, yes, being the head of a company, I get hundreds and hundreds of emails a day, so I really have to focus on wading through the unimportant ones and paying attention to the ones that are very important.
Excuse was that just for me?
Ms. Garcia, you're having some technical difficulties again. It happens. It's completely okay. You might want to just turn your camera off for a moment and turn it back on. Sometimes that just resets the bandwidth.
The plaintiff is fine if they want to pause time to figure this out, and so we can get back to the case at hand.
Let's go ahead and pause and while we figure out the technical difficulties.
I can hear you guys fine now. I'll ask a couple questions like this if that is okay. And then if I can resume to having my camera on, I will.
Mr. McKinney, do you have any objection to that?
That's fine.
And all right, well, let's go ahead and proceed that way. Go ahead, Ms. Garcia.
Okay, I will re-ask my last question. Ms. Doncourt, do you get many emails a day?
Yes, I do. As I mentioned, I'm the head of a company, so I do get hundreds of emails on a daily basis. So I have to wade through them and look for the important ones, which is why I think if I got this, I would have remembered it.
What do you mean by you would have remembered it?
Well, if you direct your attention to a top, it says that importance is high and that sensitivity is confidential. So I believe I wouldn't have let it pass over my head. So I think this email is fake.
And why do you think this email is fake, Ms. Doncourt?
Well, also because we allowed the plaintiff lawyers to search through our email system and they did not find this anywhere in there.
Ms. Garcia, if you can try turning your camera back on. Oh, there you are. Okay.
Ms. Doncourt, do you understand the preparation for Drufo?
Yes, I do. I am always informed about the preparations we take to prepare our products.
Does Lush Fertilizer at all bake their Drufo?
No, we do not.
Why not, Ms. Doncourt?
We don't bake the Drufo because the baking process was simply just an extra cost for the very little risk that it would alleviate.
So would you say profit is the reason you decided not to bake Drufo?
Well, I would say profit definitely had an influence in my decision. However, it wasn't the sole purpose. The sole reason we didn't bake it was because it was just unnecessary because we found no risk there in the first place.
No further questions, Your Honor.
Thank you. Mr. McKinney?
Good afternoon, Mrs. Doncourt. Just want to go into the discussion of finances and questions along that matter. You had a spouse, Ms. Doncourt?
Yes.
Objection relevant?
Mr. McKinney, response?
This all goes towards financial motive, Your Honor. A highly relevant topic in this case, especially when dealing with a company who has to make financial decisions, including in relation to Ms. Doncourt's personal life.
Ms. Garcia, any reply?
No response, Your Honor.
I'm going to sustain the objection at this time.
Okay, Your Honor, thank you. You take every step to prevent harmful substances from entering the environment.
Yes, of course. I'm an avowed environmental.
Exactly. You said it yourself, 10% of your annual profits go towards nitrogen footprint, preventing a bigger nitrogen footprint.
Yes, they do.
You claim the company is just a steward of good environmental practices.
Yes, we are.
Surely then you would take every step to prevent even the possibility of harmful substances being entered into the environment.
Yes, we would take every step.
So you bake the product to remove potential carcinogenic properties, any potential.
As I mentioned, we did not bake our product.
Even though this step would remove the potential carcinogenic properties.
Potentially, yes, but there was no risk in the first place.
You had the funds to bake the product, seeing as you have enough to spare for charitable contributions, correct?
Yes, we did.
Other than the direct preventative measures, you had a team designed to catch unsafe elements of Lush fertilizer, correct?
I'm sorry, can you reiterate the question maybe?
I apologize, I stuttered a little bit. You had a team designed to catch unsafe elements of Lush fertilizer.
Yes, we did. That's our research and development team.
Yeah, and if this research and development team raised concerns about the safety of this product, you would address them directly.
Yes, of course.
You are aware of the email sent to you advising against the release of the product, correct?
I'm aware of this email.
Please let the court know that I'm showing opposing counsel and the witness Exhibit 4, which has previously been entered into evidence. Jerry Langley is one of your employees, correct?
Yes.
He is your product manager of Drufo?
Yes.
That is your name on the list of individuals that the email was sent to, correct?
Yes, that's my name.
In the second paragraph of this exhibit, it states that concerns have arisen regarding the generalized findings about potential carcinogenic qualities identified in samples produced during a period early in the year.
Testifying?
I'm sorry, I just didn't hear you, Ms. Garcia. What was the objection?
I said I objected to the attorney testifying.
Response?
This is a leading question. I'm saying it states that, and I followed up with a quote, and giving the opportunity to Ms. Doncourt to answer. This is a leading question.
Any reply, Ms. Garcia?
Yes. One of our other attorneys got a sustained objection. So I think this, for doing the exact same thing, I think this should be sustained as well.
I'm going to overrule the objection. The form of the question was appropriate. Go ahead, Mr. McKinney.
Once I'm going to restate this question. In the second paragraph, it states that concerns have arisen regarding the generalized findings of potential carcinogenic qualities identified in samples produced during a period early in the year. It says that, correct?
Yes, it does.
So you claim it was a big hoax, a fabricated email, and you're unaware of it existing.
Yes, I do, because if I had seen this and if there were things saying that Drufo needed to be reopened.
Ms. Doncourt. It was a yes or no question. Carson Durst was fired, who was tasked with the safety management of your product.
Sorry, could you repeat the first half of that question?
Carson Durst was fired, the product safety manager of your product.
Yes, he was.
Not manager, sorry, tasked with the safety of your product. Anyway, sorry. The unbaked product was released for public use.
Yes.
No warnings laying out potential carcinogenic properties were provided to the customers.
No warnings specifically about cancer, but there were general warnings about use of chemicals.
Thank you. And once again, the product was unbaked.
Yes, it was unbaked.
You claim you're an avid environmentalist, Ms. Doncourt?
Yes, I do.
Thank you, Your Honor. No further questions.
Right, any redirect?
Yes, Your Honor. Were you aware, Ms. Doncourt, of the possible carcinogenic properties of Drufo at the time of research?
Yes.
Could you re-say that? I'm sorry.
I said yes.
Okay, moving on. At the time, could you recall getting the email mentioned in Exhibit 4?
By at the time, do you mean?
Objection. This question's been asked and answered.
Any response, Ms. Garcia, to the objection?
I'll move on. No further questions, Your Honor.
All right. Any recross, Mr. McKinney?
No, thank you, Your Honor.
All right. Will the defense please call their next witness?
The defense calls Skylar Reese to the stand. Could you please introduce yourself to the jury, stating your first name and
1 minute, Ms. Gingras. Let me just swear the witness in.
Oh, yes, sorry.
That's okay. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead, Ms. Gingras.
Could you please introduce yourself to the jury, stating your first name and spelling your last for the record?
Yes. My name is Skylar Weers. Weers spelled W-E-I-R-S.
Mr. Weers, could you please tell the jury why you're here in court today?
Yes. I'm here today because of my testifying on behalf of Lush Fertilizer and because of my research I've done on fertilizers, as well as Lush Fertilizer and Drufo.
Are you acquainted with the plaintiff, Mr. Weers?
I am, yes.
How are you acquainted with the plaintiff?
The plaintiff is my twin brother.
Are you close to your twin brother?
As family, we are brothers, so in that case, yes.
Like
However,
relevance.
Response?
Your Honor, this question is relevant because as the witness is testifying against their twin, I need to build foundation as to why they're here in court today.
Any reply?
No reply.
I'm going to overrule the objection, pending that it goes to motive and bias. Go ahead, sir. Or I'm sorry, go ahead, Ms. Gingras.
Why are you here testifying against your twin, Mr. Rears?
I'm here testifying against my twin because of my research on companies and on the production of fertilizers that I've brought today on describing Lush fertilizer and Drufo, because it contradicts my brother's belief that Drufo, or Lush's fertilizer specifically, has caused his cancer.
You mentioned research. How does that play into your profession, Mr. Rears?
That plays into my profession, as I am an investigative journalist by trade. I work as one for the nonprofit organization, The Rationalist.
How long have you been working with The Rationalist, Mr. Rears?
Ever since I have graduated from high school, so a couple years now.
Do you have a degree, Mr. Rears?
I do not know.
When writing, do you do your own research?
I do my own research by extensively reading over information from labs, journals, and such that are gathered by sources pertaining to government and government-funded organizations. I take their information, I relay their information, and I compound them to prove my thesis.
When writing and presenting your research, do any of your writings contain your opinion, Mr. Rears?
No, they do not. I am simply relaying the information I've gathered from these organizations that prove a certain side.
What sources do you use when researching, Mr. Rears?
Namely, government-funded organizations, so the USDA and NSDA is what I primarily have used.
Are these sources reliable?
Yes, they are reliable. They're government organizations, so in that case, they would be.
Have you written about Drufo with The Rationalist?
I have, yes.
Have you written about the health effects of Drufo with The Rationalist?
Apologies. I have, yes.
Your Honor, I move that Skylar Weirs be recognized as an expert in investigative journalism and the health effects of Drufo and fertilizer.
Your Honor, the plaintiff would like to conduct a voir dire on this witness's credentials.
Okay, the court will allow a very brief voir dire.
All right, thank you. Now, Mr. Weirs, are you a biologist?
I am not. I am a journalist.
How about a chemist?
I am a journalist, so no.
A yes or no will do. A medical doctor?
No.
Do you have a degree in toxicology?
I do not.
Do you have a degree in agriculture?
I do not.
Do you have a medical degree?
I do not.
Do you have any degrees?
I do not. However, I do have my years in experience
Thank you.
that I
Yes,
gained.
you do. Yes, you do. Thank you. Your research is from the USDA and NASDA, correct?
They are.
This is public information.
It is generally public. It is published.
All right.
So yes.
So anybody can access it.
Yeah.
All right, Your Honor, the plaintiff objects to this witness being qualified as an expert, as there is a lack of foundation, and there is this witness does not have the proper credentials or specialized knowledge to be an expert in the defense's previously stated request.
All right. Mr. or Ms. Gingras, do you have any response to the objection?
Your Honor, I asked that I moved that Skylar be entered as an expert in investigative journalism and nothing but investigative journalism.
I apologize, Your Honor. If the defense is just saying the investigative journalist, the plaintiff has no objection.
Okay, then the court will admit the witness in the area as an expert in the area of investigative journalism.
Mr. Weirs, writing about Drufo, what did you write your articles about specifically?
I had written my articles about the evolution and use of pesticides and of fertilizers over time. I've also written about such evolutions pertaining to Lush's fertilizer in general, and how its product and how its component Drufo has revolutionized the market of fertilizing.
According to your research, how do fertilizers work?
According to my own research, I found that fertilizers work by replenishing the nitrogen within the soil that is used over time as it puts that
Objection,
nitrogen.
Your Honor, lack of personal knowledge.
Response?
Your Honor, this witness has previously been identified as an expert in investigative journalism. He is merely stating what he has done for work as an expert in investigative journalism.
Reply?
This is not a matter of investigative journalism. This is more of a scientific information, which this witness has not been qualified for.
I'm going to sustain the objection, finding that the question calls for expert testimony in areas in which this witness has not been qualified as an expert.
May I move on to my next question, Your Honor?
Yes, Ms. Gingras, go ahead and continue with your direct examination.
What have you read about that makes these fertilizers cancerous, Mr. Rears?
Generally, fertilizers are their components within the fertilizers, such as nitrogen, like I've mentioned before, is generally known to be cancerous, as well as the installment of pesticides within fertilizers, which is relatively common. These often contain components which have elements and compounds such as glyphosate and arsenic.
Objection, Your Honor. Again, lack of personal knowledge.
Response?
Your Honor, I posed the question in which he was stating what he has read as an investigative journalist, which he has been identified as an expert in.
The witness's testimony is referring to scientific information, which is again out of his expertise.
All right. I am going to find that it is outside the expertise, but for the purposes of this proceeding today, I am going to allow the witness to continue with his testimony. So go ahead, Mr. Rears, you can continue with your testimony.
Could you re-ask the question, Ms. Gingras?
Mr. Rears, what have you read about that makes these fertilizers cancerous in your investigative journalism career?
All right. So with fertilizers and how they are commonly made, they include the element that I've mentioned before, nitrogen. It is generally known to be cancerous. As well as that, we have the installment of fertilizers within these, the installment of herbicides and pesticides within these fertilizers. These most likely contain elements and components, or elements and compounds, sorry, such as glyphosate and arsenic, which are also generally known to be toxic and cancer causing.
Thank you, Mr. Rears. No further questions.
Mr. Street?
Yes. No, you're fine. I would like to do a cross.
Go ahead.
You are a journalist, Mr. Rears?
Yes.
Specifically an investigative journalist.
Yes.
The Rationalist, and you write for the Rationalist magazine.
Yeah, it's a nonprofit organization.
All right. Thank you. A yes or no will do. The Rationalist magazine promotes scientific skepticism.
It does.
So you promote questioning scientifically proven facts.
I do.
All right. And so you're paid to do research.
Yeah.
And you're also being paid to testify today.
Yeah, you could say so.
Is it correct that you gamble?
It is a hobby of mine.
Objection, relevance.
This goes to financial motivation of this witness.
Any reply, Ms. Gingras?
Your Honor, this question isn't specifically about financial bias. It's about his hobbies, which I don't think should be relevant within this case.
I'm going to overrule the objection, finding that the question relates to motivation or bias. Mr. Streeter, go ahead and continue, or Mr. Rears, you can answer the question.
Very well. Could you re-ask the question, please?
Of course. You have debts from this gambling, correct?
Yeah, you could say so. It's It's I do gamble and I am in a debt which I'm getting out of.
All right. Your family has helped pay for the debts.
No, they have not.
Your family in the past has paid for the debt, helped pay for the debts.
They have in the past, correct? Yeah.
Okay. And they've stopped helping.
They have stopped, yes.
And your father has promised to help pay for Dakota's medical bills.
Yes, he has cancer.
And they stopped helping you with your gambling debts, correct?
Because of that, yes.
Okay. And so you're in need of money.
I am.
All right. No further questions, Your Honor. Thank you.
Any redirect?
No, Your Honor. Thank you.
All right, thank you. Would the defense please call our next witness?
The defense calls Dr. Devin Williams to the stand.
All right. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do. Yes, I do.
Go ahead, counselor. You may begin.
Good morning, Dr. Williams. Could you please introduce yourself to the jury and spell your last name for the record?
Yes, my name is Dr. Devin Williams, Williams.
What is your current job?
I am the lead of the R&D department at Lush Fertilizer.
And what is the R&D department?
The R&D department does anything from general research about Lush's products to hands-on research in the labs.
And which state do you work in?
I work in Colorado.
Dr. Williams, could you tell us a bit about your education?
Yes, I have a undergrad through PhD in all fields like toxicology from Colorado State University. And after I did that, I went to University of Utah, where I got a post-degree course award certificate for toxicology.
Dr. Williams, do you have your exhibit notebook in front of you?
Yes.
I would now ask for the... Pardon? Oh, sorry. Apologies. Dr. Williams, I would now ask for the court opposing counsel and Dr. Williams to address your attention to what has been previously marked for identification purposes as Exhibit 9. Dr. Williams, do you recognize this report?
Yes, this is my curriculum vitae.
Is it a fair and accurate representation of your curriculum vitae?
Did we get everything? Yes, it did. Yes.
Your Honor, I move for the admission of what has been previously marked for identification purposes as Exhibit 9 into evidence.
Any objection, Mr. Sempro?
No, Your Honor.
Exhibit 9 will be admitted.
Dr. Williams, you mentioned working as a toxicologist. Would you explain what that entails?
Yes. So there's two main things in toxicology. The first is to understand certain chemical traits between different compounds, like, oh, this will have a certain like geometry to it, or this has a certain color to it.
Objection, Your Honor. This witness's answer is outside the scope of the mock trial statement. This is containing knowledge that is not available inside of the case problem.
Is there any response, Ms. Weidman?
Yes, Your Honor. I believe that the profession of toxicology is not one that needed to be identified within the problem. Toxicology is a real life profession, and the witness is testifying to what that is.
May I respond, Your Honor?
Go ahead.
Opposing counsel, the witness cannot testify to anything that is outside of the mock trial case problem, regardless of what that is. That's hearsay, and that is outside of the scope of the witness and the mock trial case problem. So he cannot say that.
All right, I'm going to go ahead and sustain the objection, Ms. Weidman, and the witness, if you would just focus on the information contained within the mock trial packet.
All right, Your Honor. Dr. Williams, do you have any certifications?
Yes, I do.
What certifications do you have?
I have many certifications related to the field of toxicology, specifically clinical toxicology and forensic toxicology.
And which states are you certified in?
4 states, Utah, New Mexico, Colorado, and Wyoming.
Your Honor, I move to enter Dr. Devin Williams as an expert in toxicology.
Any objection?
Your Honor, no objection, but I would like to conduct a voir dire.
Okay. If you're not objecting, I wouldn't typically allow for a voir dire. Are you asking to voir dire before?
I would like to voir dire the witness, please.
All right, the court will allow for a very brief voir dire.
So you previously testified that you had a post PhD, something relating to toxicology. Is that correct?
Yes, a post PhD course at University of Utah.
Okay, perfect. I was just wondering if you could take a look at Exhibit 9, please. Your curriculum vitae.
I'm looking at it, yeah.
All right, perfect. And in the education section, does it ever mention that post-PhD toxicology thing that you took? Just under the education section at the very top, it should say.
No, it doesn't. My apologies.
Okay, so
it does say it in my witness statement, though.
Okay, but does that mean that your curriculum vitae is inaccurate?
It is not entirely complete. If you'd like, it's first page of my witness statement.
Okay, I understand that. I was just trying to clarify. So your curriculum vitae does not contain information in your witness statement.
Yes.
Cool, thank you. Your Honor, I would just like to object to this witness being an expert in toxicology.
I'm going to overrule the objection, finding that a proper foundation has been laid. This witness will be admitted as an expert in toxicology. Go ahead, counselor. You may resume with your direct examination.
Thank you, Your Honor. Dr. Williams, how does DRUFO work?
So DRUFO is the bonding agent in many of our fertilizers. What it does is it is inside of our fertilizers and it attaches to the soil as well as to the plants that it's sprayed on. And it's a more efficient way of bonding fertilizers because sometimes fertilizer that is sprayed.
Your Honor, this is outside of the witness's expertise. The witness is qualified as an expert in toxicology. However, explaining how DRUFO works is not something that relates to toxicology. And this is outside of their expertise.
Ms. Weidman?
This is within the witness's expertise, as pesticides are covered in toxicology, and understanding how they work is basically the core of this work.
I'm going to overrule the objection and allow the witness to continue answering.
Yeah, so DRUFO bonds to the soil, bonds to the plants, and sometimes if fertilizers are sprayed, sometimes that fertilizer won't actually bond and it'll just sit there and turn into nitrates.
Dr. Williams.
Oh, Ms. Weidman, you're muted.
My apologies. Dr. Williams, in your professional opinion, does DRUFO cause non-Hodgkin lymphoma?
No, it does not.
Objection, that has nothing to do with toxicology. That is his opinion on what something causes, which can be diagnosed by a medical doctor, but not by somebody who's an expert in toxicology.
Ms. Weidman?
Toxicology also involves understanding how that affects the environment and, by proxy, how it affects humans. So this is, in fact, covered by Dr. Williams' expertise.
Ms. Weidman, that may be the case. I'm going to ask that you lay a little further foundation for that question.
Pardon me for asking, but in terms of what toxicology entails?
Yes.
All right. Dr. Williams, would you explain what toxicology entails?
Yeah, so as I was saying earlier, there's two main things. The first was that I can see markings on different chemicals. The second is I can understand how certain chemicals can affect the human body.
So, Dr. Williams, in your professional opinion, does DRUFO cause non-Hodgkin lymphoma?
No, it does not.
But is there any way to know for certain if users of DRUFO will contract non-Hodgkin lymphoma?
No, there's no way to do that. And this is because when you take a sample group of people and say how many of them have
Objection,
cancer.
Your Honor. Narrative. This witness is going on. I would prefer if the opposing counsel would split this question into multiple parts so the witness can answer that instead of going on a narrative.
Ms. Weidman?
Your Honor, I will ask further questions. My apologies.
Okay, I'm going to overrule the objection. I don't find that it was narrative. Some questions result in requiring longer answers. But Ms. Weidman, if you'd like to ask a separate question, certainly you may do so.
Thank you, Your Honor. Why is it not possible to know for certain if users of Drufo will contract non-Hodgkin lymphoma?
So, excuse me, can you ask the question again?
Yes. How is it, my apologies. Why is it that it is impossible to know for certain if users of Drufo will contract non-Hodgkin lymphoma?
If you take a sample group of people and just see how many of them have cancer, there is a possibility that some people will have cancer, and there's no direct way of tying the Drufo or certain chemicals to that group of people.
Thank you, Dr. Williams. I'd like to move on to Casey Rogers. Did you hear Casey Rogers' testimony today?
Yes, I did.
And do you recall the study discussed?
Yes.
What do you think of this study?
Well, this study.
Objection, Your Honor. This is outside of the witness's testimony. Outside of the witness's scope. They were qualified as an expert in toxicology, and reviewing somebody else's study is not related to toxicology, and they have no knowledge of this. Therefore, it is outside of their knowledge.
Excuse me, Your Honor, you were muted.
Ms. Weidman, any response?
Yes, Your Honor. As a scientist, toxicology being a science, Dr. Williams is a scientist, and a major component of the scientific method is peer review. And that is simply what Dr. Williams is doing right now. So it is completely within the scope of his expertise.
Any reply, Mr. Sempera?
No, Your Honor.
Right. The court's going to overrule the objection. Go ahead, sir. You may continue testifying.
I'll re-ask the question. What do you think of Casey Rogers' study?
Study looks at the wrong data set. It looks particularly at people who use Drufo fertilizers a lot, a little bit, and not at all. And the problem with that is people who use fertilizers a lot, like farmers and homesteaders, are constantly around all sorts of chemicals and in a completely different lifestyle than those of people who don't use fertilizers at all, or people who use Drufo fertilizers very little, just like backyard gardening. So it is a completely different study than the ones we're supposed to be looking for. A better study would be to look at people who use fertilizers quite frequently.
Your Honor. Narrative, this witness is now answering a question that was not asked.
Response?
Your Honor, I believe that this question is, the answer that the witness gave did pertain to my question. I asked him to explain his thoughts, and he is giving his thoughts.
If I may respond, Your Honor.
Go ahead.
I'm not objecting to his previous answers, opposing counsel. I am merely objecting to what he thinks that the thing should have done, which was what he was just about to explain. I would just prefer if you could split that into another question.
I'm gonna overrule the objection. You can go ahead and continue with your answer, Mr. Williams, Dr. Williams.
So a better study that would have been better to conduct would be one that compares people who use fertilizers quite frequently and that have Drufo, and a study that does the same category of people, but with a fertilizer without Drufo. And because that study doesn't exist, there's no real way of proving whether Drufo can cause cancer or not.
Thank you, Dr. Williams. Your Honor, I have no further questions.
Mr. Sempera?
I would like to conduct a cross-examination, Your Honor.
Go ahead.
Okay. Thank you. Dr. Williams, do you currently work for Lush Fertilizer?
Yes, I do.
So you currently get paid by Lush Fertilizer?
Yes.
So you'd be unemployed if Lush Fertilizer went out of business?
Yes.
Okay. And you're currently representing Lush Fertilizer?
Yes. More importantly, I'm representing Drufo.
Oh, okay. Perfect. Thank you. And so is it true that Drufo is really banned in the European Union?
Yes, it is.
Okay, wow. All right, that's crazy. And isn't Lush Fertilizer currently attempting a bid to get approval to sell Drufo products in the EU?
Yes. The people in the EU didn't do that study correctly.
Excuse me, it's a yes or no.
Objection, badgering a witness.
Response?
I'm not. I'm merely asking them a question, and I'm just trying to get clarification and elaborate to prove my point.
Your Honor, may I respond?
Go ahead.
All right. I am objecting to the yes or no clarification as my witness swore to tell the whole truth. This may not be confined to a simple yes or no.
Your Honor, if I may respond just one more time.
I'm not going to allow another response because of the time constraints that we have. I am going to overrule. Well, I'm going to sustain the objection. Mr. Sempera, if you would just refrain from commenting after the witness testifies and just ask questions.
Okay. Is it true that Lush Fertilizer is currently attempting to get approval in the EU?
Yes. The EU made a mistake and we're trying to fix that problem.
And would this lawsuit affect Lush Fertilizer's attempt to get approval to sell in the EU?
Yes, it would.
All right, thank you. Just like a couple more questions here. You are the leader of the R&D toxicology team at Lush, right?
Yes.
And is it true that baking the fertilizer would remove even the slightest risk of carcinogens being in the final product?
Yes, it would, but it's an unnecessary precaution.
But it would remove even the slightest risk?
Yes.
Okay. But you didn't bake the Drufo, did you?
No, we did not.
You didn't recommend that Drufo would be baked?
No.
Okay. So there is a chance that carcinogens could be in the final product, however small, but there is a chance.
Sure, there's always some chance, like I was saying.
Okay, perfect. Thank you so much for your time, Dr. Williams. Your Honor, the plaintiff has no further questions.
Any redirect?
No, Your Honor.
All right. Thank you, Dr. Williams. Does the defense have any additional witnesses?
No, Your Honor, the defense rests.
All right, we'll go ahead and proceed to closing arguments. Beginning first with the plaintiff, Mr. McKinney.
Thank you, Your Honor. First, though, I would ask to reserve any time at the end of my closing statement for rebuttal.
All right, any time left remaining will be reserved for rebuttal.
All right, thank you, Your Honor, and thank you, opposing counsel. Ladies and gentlemen of the jury, every day we are faced with choices. We choose what we like, who we spend time with, and what career or path fulfills us the most. Dakota chose a path that fell in line with his love for piano, and his work in landscaping supported him through that. He chose to work knowing that the different products he worked with would be safe and wouldn't prevent him from pursuing his dream. He worked every day, for weeks, for months, for entire summers with Lush Fertilizer. Well, Lush Fertilizer had a choice too, but more importantly, they had a responsibility. They chose to knowingly release a carcinogenic product, and now Dakota lives with their decision, and he cannot choose to leave. Let's examine what our job here as the plaintiff is today. We have to prove beyond a preponderance of evidence that Lush Fertilizer produced a dangerous product and failed to warn the plaintiff, causing damages due to company negligence. Did the defendant knowingly ruin Dakota's life due to an awful and preventable illness? Blake Doncourt, an avid environmentalist who would never wish harm on the environment, demonstrated that she produced the product with Drufo, not even baking it to remove the possibility of carcinogenic properties for the sake of money. The company claims they were unaware of any carcinogenic properties, but in the redirect of Mrs. Doncourt, she said she was aware of potential carcinogenic properties. There are entire inconsistencies here. But let's just not work with possibilities of carcinogenic properties. Dr. Casey Rogers demonstrated the carcinogenic risks of using Drufo. A study that observed agricultural workers who were exposed to Drufo correlated with an increase in cancer, specifically non-Hodgkin's lymphoma. Clearly, This isn't some one-of-a-kind issue, as this is a health problem that many have experienced. Lush Fertilizer knew it wasn't some outside private consultant making claims of carcinogenic properties. It was the members of their own team hired to make sure that the products were safe. Carson Durst demonstrated the falsehoods produced by the company. Let's keep it in the walls. Words uttered by a member discussing potential carcinogenic properties of Drufo. As demonstrated in the email that most certainly passed under Don Court, further studies were needed as there were potential carcinogenic properties in Drufo. Evidence was found exposing the carcinogenic properties, and all Don Court could say was it was all a hoax, a revenge for Carson Durst, who was only hired to make sure products were safe. Blake Don Court had every motive to sweep the problem under the rug, as sacrificing dollars to safety would just be a financial waste. The company knew the risks and didn't even bake it or simply provide proper warning about potential carcinogenic properties. Skylar Weirs aimed to lay out the claim that there are no carcinogenic properties. Armed with only a high school diploma, Skylar's provided the court with a demonstration of her resentment of her ill brother. Gambling debts should not be the motive for testimony. Let's go back to the damages we are trying to quantify here. A music school opportunity inspired by a connection with his grandfather was cut short by an irresponsible company. Dakota has to endure the pain of a debilitating illness while also enduring the lack of accountability from a company he works so closely with. Every day he wakes up with severe pain, swollen lymph nodes, and the psychological damage of living with a debilitating illness. The irresponsibility on behalf of the company is disgusting. They chose not to bake it. They chose not to listen to their own team advising against the product. They chose to ignore further evidence of carcinogenic properties. They simply chose wrong. We cannot go back in time to stop this terrible illness. But today, ladies and gentlemen of the jury, you do have a choice in how this ends. You each have a part to play in justice. We are asking for the sum of $3 million for Dakota, a small price for someone who may not live to see 30. Choose for someone who wasn't given a choice. Choose in favor of the plaintiff. Thank you.
Thank you. And for the timekeepers, how much time is remaining?
1 minute and 16 seconds.
I have 1 minute and 17 seconds, so I think we're pretty okay.
All right. Ms. Weidman?
Thank you, Your Honor. Lush is not liable. Ladies and gentlemen of the jury, today you are presented with a case of tragedy. A young man was left with a debilitating disease that all but ruined his life. However, this must not be a case ruled by sympathy or emotion. You were asked to evaluate the involvement of Lush Fertilizer in Dakota Weir's case, in which there was none. As the plaintiff has the burden of proving their claims by a preponderance of evidence, they had to prove all four of the following claims true. 1, that the defendant manufactured a fertilizer product containing a chemical known as Drufo. 2, that the plaintiff was a person that reasonably would be expected to use the product. 3, that the defendant was negligent by failing to exercise reasonable care to prevent the product from creating an unreasonable risk of harm to people expected to use the product. And 4, that the plaintiff had damages that were caused by the defendant's negligence. The first claim is, by all accounts, true. Lush Fertilizer has never denied its usage of Drufo. The second statement is also true, but not in dispute. It is reasonable that Dakota Weirs would use the fertilizer. However, the third claim, that Lush Fertilizer failed to exercise reasonable care in preventing unreasonable risk of harm, was proven to be false based on the testimonies you heard today. Dakota Weirs has confirmed that there were safety recommendations on the Lush Fertilizer packaging, which were ignored. The proper studies were conducted and acted on. Dakota Weirs ignored these signs. The plaintiff failed to prove this claim true. And the final claim, that the plaintiff had damages caused by the defendant's negligence, is also false. Lush Fertilizer did not neglect the safety of its users. Dr. Devin Williams, an expert in toxicology, has confirmed today that the risk of Drufo users developing non-Hodgkin lymphoma is no greater than that of any other fertilizer. There was a safety recommendation on the package. Mr. Weirs was advised by his supervisors to follow these. However, tragically, Dakota Weirs did not listen. Now, while 2 of these claims have been proven true, the plaintiff needed to prove all 4, and they have failed. Along with the plaintiff's burden of proving his claims, the defendant has the burden of proving the affirmative defense by a preponderance of evidence. As per jury instruction number 8, the defendant needed to prove the following 2 statements to be true. 1, that the plaintiff failed to do something that reasonably careful people would do, and 2, that the conduct by the plaintiff was a cause of his claimed injuries, damages, and losses. We proved both statements to be true today. Dakota Weirs ignored the obvious safety recommendations of the packaging and directly disobeyed his employer's instructions. A reasonable person would take caution when dealing with intense chemical compounds such as Drufo, and yet Dakota Weirs did not. He refused to comply with these safety regulations, and tragically, his actions had dire consequences. He did not need to feel the wind on his face. He was dealing with intense chemicals. He should have worn log pants, should have worn gloves, should have worn a mask. At the least, he should have washed his hands before and after use of Drufo and all fertilizers, but he did not. Dakota Weirs failed to treat these chemicals in a reasonable manner, and his conduct is a direct cause of his claimed damages. If Drufo does cause non-Hodgkin lymphoma, all of the proper safety recommendations were advised properly. Dakota Weirs should have treated these chemicals in a safer, more reasonable manner. And yet, tragically, his negligence resulted in his own misery. This case is undoubtedly a devastating one. A young man's life was ripped from him, forcing him to find a new purpose. However, you must not rule based on sympathy. You must not be swayed by the tragedy you saw unfold before you today. And when that sympathy is removed from this story, you will find that it was entirely avoidable. And on top of all of that, Dakota Weirs worked with numerous fertilizers. He's going after the one that became the most successful. Of course, the defendant, our heart breaks for Mr. Weirs. We hope for nothing but the best for them. But at the end of the day, Lush is not liable. Thank you.
Permission for rebuttal, Your Honor.
Yes, please go ahead, Mr. McKinney.
All we have heard from this closing argument is should have, would have, could have on behalf of the plaintiff, Dakota Weirs, a mere employee of a system that was corrupt, failed to warn its employees of potential carcinogenic properties. Reasonable care, the company did not exercise reasonable care. They chose to ignore the evidence. They chose not even to bake it. They chose to release a product with no carcinogenic warnings. Other fertilizers used by Dakota don't matter. What matters is that we prove that Drufo has carcinogenic properties. They chose wrong, ladies and gentlemen. Please choose in favor of the plaintiff. Choose for someone who couldn't. Thank you.
All right, thank you. Let me go ahead before we wrap up. I do have to ask one question. Are there any inside the bar disputes? I don't hear any response. Mr. McKinney?
Oh, sorry. I was just saying no, there is no in-bar disputes that we can think of.
Ms. Weidman?
No, we have no disputes.
Folks, I'm going to ask that everybody please turn on their cameras. First and foremost, on behalf of the scoring panelists and myself as the scoring panelists are working on submitting their scores, I want to congratulate all of you on a job well done. You all are very impressive, and I have the opportunity to have attorneys appear before me every day, and you guys are certainly on an amazing path towards becoming very effective attorneys if that's the profession you choose. And to the witnesses, phenomenal job. I think what we would like to do, we don't have a ton of time, but myself and the scoring panelists would like each to take just 1 to 2 minutes to provide you some feedback. But But overall, I want you all to leave this competition today and this weekend knowing that you did a wonderful job. All of the work and effort you've put into this is evident, and I really do congratulate you on a job well done. Would any of the scoring panelists want to make a few comments?
Sure, I can go first.
Go ahead.
Thank you, Your Honor. First, I want to reiterate Magistrate Boxberger's comments. That was a pleasure. I thought you guys did amazing. I practice in court fairly often, and I think I completely agree with her comments about being on the right course towards, if this is a profession you choose, to becoming really good attorneys. So good job, everybody, first of all. A couple specific comments. I really enjoyed Tensing and Paige's objections and back and forth on objections and responses. That was really good. Those can get tense between attorneys, so good job keeping it professional. I think, well, I wanted to say that as well. I think everybody did great professionally. There was didn't seem to be any over aggression or anything like that, which can happen in the courtroom, as Magistrate Boxberger could attest to, but I didn't see any of that today. So good job on that front. Couple other specific comments on cross-examination is hard. You want to slow down a little bit. I think a couple people were just a little quick because they wanted to get to their questions that they had written down, as opposed to listening to the answer from the witness. So I think it's a really good skill to learn, to listen to the answer, because the answer may not be what you're anticipating. If the answer is different, you want to ask another question based on that answer. So don't just have a list of questions on cross. It's good to have an outline of what you want to ask, but don't be, I guess, regiment that list so much, listen to the answer and then go off of the answer and maybe ask a follow-up question to that. So that's just a general practice point on cross. And then other than that, I think I don't have much else. So good job. Thanks a lot.
Okay. Any of the other scoring panelists?
I'll go next. Hi, my name's Tracy Oldemeyer, and I also very much enjoyed this competition. This was my first one of this year's competition that I've been a scorer at, and want to commend you in particular for the technology and how you, from my perspective, did a phenomenal job presenting your cases in this remote setting. It's not easy. So from a scorer's perspective, we were able to hear, see, interpret all of that really well. So job well done there. Just a few 30,000 foot view comments. I think, again, there are definitely standout attorneys and standout witnesses in this case, in part because of substance and in part because of your practice and polish. And I saw it. I think each and every one of you definitely have qualities that make you stand out and where you definitely shine. But I wanted to comment in particular on one thing because it might help both teams go forward. One thing I found very valuable was, is it Dr. Williams? Dr. Devin Williams? Yep. We can see him very clearly. He said, I want to make 2 points. He always had his two fingers and we could see it in the screen. He was very articulate and very animated, and that helps. So some witnesses, you're back or you're slouched or you're this or that. Those tips you have about presentation skills, think about them all the time and don't lose sight of it. You've done this a million times, but that was really helpful to a scorer and a juror understanding his testimony. And last but not least, again, cross-examination is always fun. And when you score a good point, you don't want to blow it by asking a follow-up question like, did I hear you right? Did you just agree with me? There were lots of times where I thought the attorney was surprised by a witness's answer on cross. So kind of do that mic drop, pause, let silence be the power, and then move on to your next subject matter. But I was really impressed with all of you and would encourage you not to show reactions, have your poker faces on, keep your tone always neutral. You are a mouthpiece. You're not arguing when you're accepting openings and closings. So job well done, everybody.
And is it Miss Larinaga? I'm probably mispronouncing your name.
Yeah, no worries. It's Larinaga, but no one gets it.
So I did. Okay, go ahead.
Yeah. I was just gonna say, like the other jurors have said, you guys' professionality was really, really good. The only thing I would also suggest is that this case like the back of your hand. Just kind of trust yourself a little bit more with going within the moment things rather than relying on everything you've prepared. But everything you've prepared was also wonderful.
And I agree. So I'm going to tell you a brief story. When I was a Young County Court DA in Adams County, I had to prepare 7 cases for trial, all set for the same day. And I thought, there's no way we're going to get to the 7th trial today. So I am not going to prepare it as well. And guess what? We got to the 7th trial and I was stuck before the court without my notes, without my outline of my questions. What I learned was I had to, in order to do an effective job, I had to listen to the witnesses and then form my question based upon their answer. And that's something that's very hard to learn. And you guys are years ahead of where I was when I was a Young County Court DA. That's evident. But I echo those comments. Just a few practice tips would be to have your outline, but don't rely on it. Make sure you're listening to the answers that are given and be able to adapt to that. If that means you have to make a note to say, if your witness takes you in one direction and that's not the direction you wanted to go, make a note on your notes, come back to this at a later point, and just be flexible. I do want to tell you, you guys all did a phenomenal job. It was clear that the witnesses knew their parts very well. I do have to comment because I thought I was witnessing a real trial at one point. I was just enthralled, and so I would be remiss not to point this out. But when Sarah Lindquist testified and Chase, you were the attorney directing her. I thought you two, it was like you had prepped like attorneys and witnesses do in advance of trial. It was very smooth. Both of you knew your roles very well, and you were a very good combo together. And Chase, I just want to say, I might need you to come help me teach an evidentiary here, CLE at some point, because you knew the rules of evidence, and you were very, you want to be careful when you object not to make a speaking objection, and you didn't. You were very to the point, and I have to commend you with your knowledge of the rules of evidence. It was phenomenal. I was very, very impressed. And your redirect with Ms. Lindquist was very brief and to the point. You got out the 2 issues you needed to get out, and then you left, which is, I think, a mistake veteran attorneys make, is that they go too far. Like Ms. Oldemeyer was saying, when you get that mic drop moment, take it and walk away. Don't try to recreate it. And then again, you guys did a phenomenal job, and some of the comments that we've made are so that you can continue to improve. Don't ever get argumentative with your witnesses, or witnesses don't get argumentative with the attorneys. You can be passionate about your cause, but you have to remember what your tone of voice is in the courtroom. It's something I remind attorneys about frequently when they appear in front of me is remain calm, okay? Because the jury watches you, and if they see everybody getting tense, then that may not reflect well. Jurors are there to judge, and they judge everybody and everything that's done. So you have to always, no matter where your emotions are at, I have to tell myself, I have a sign on my bench that says remain patient, remain calm. You got to always remain that way, because your jurors are judging you too, not just the issue. So, but overall, I want you to leave with this: phenomenal job. I applaud you all. You did a wonderful job. Keep it up. Keep with this. You guys have so much to offer this profession, if this is a profession you choose to go in. And I'm excited hopefully one day to call some, if not all of you colleagues. So I think that concludes our statements. Do we have all of the scorecards submitted?
I believe I saw them all come through, yes.
I think we can all then leave. Good luck in the rest of the tournament, folks.
Thank you
Great,
so
thank
much.
you all. I'll
Thank you
stop the
guys so
live
much.
stream
Thank you.
and just remind everyone